and Technology. I'm moderating this panel. This panel is on long-term proposals for international data requests. The last panel, in contrast, was about a current proposal that has been put on the table for dealing with this problem. This panel is the long-term solutions panel. We are going to solve this problem this afternoon. And we have 1 hour to do it. 1 hour to do it. And I couldn't think of a better group to do it than the folks we have here. Let me introduce them real quickly, and then we'll go right into some questions. Immediately to my left is Andrew Woods. He's a law professor at the University of Kentucky. He's one of the leading thinkers and doers on cross-border data requests. He teaches cybersecurity, the regulation of technology, and contract and international law. And immediately to Andrew's left, Lani Cosette from Microsoft. She's based in Brussels, and she works on the Microsoft EU Government Affairs team. She moved to Brussels last year from the Microsoft headquarters, where she was a senior attorney working on privacy, cloud, and search issues. And then to the far left, Kevin Bankston. He's the director of New America's Open Technology Institute, where he works to promote policy reforms that support open communications networks, platforms, and technologies. Before joining OTI, Kevin directed CDT's Free Expression Project, and before that, worked on privacy, free expression, and government surveillance at the Electronic Frontier Foundation and also at the ACLU. So with that, let's just get right into it. Andrew, you're up first. I already gave you credit for being one of the leading thinkers in this area. If you haven't solved the problem already, can you kind of look back on your work, both in this area and in other related areas, and step back and abstract from that work? Are there some principles or a framework that would bring us closer to solving this problem that you could maybe identify for the group?
Yeah, I'll try. First, I need to solve the problem of this microphone. Do I flip that?
No, you flip this. You're on.
Oh, I'm on.
No, you're on.
Okay. First of all, thanks to Peter and Georgia Tech for hosting this great event. So I was thinking about the process as we, 2 years ago, Peter and Greg and Kevin and Jim Daskell and a number of others and I have started to talk about MLAT reform, and it seems almost like the first meeting was a constitutional convention. We were trying to figure out, we kept going back to first principles, like what are the base questions that need to be answered before we get any traction on this question of law enforcement access to data abroad. And what does it even mean to say abroad? Centers
I think you have to go dark for or something.
I've noticed that very similar conversations have been happening in other areas.
Yeah.
Enforcement hacking.
My first time I spent like 6 hours.
Centers, regards to questions around encryption, with regard to speech and takedown requests and privacy liability. Or there are a set of questions that need to be answered that are really first principle questions about jurisdiction over the internet. We all recognize that we live on the internet, and we all recognize that we live in a world where law comes from states and states have jurisdictions. And so we keep in different areas, discrete different areas, keep bumping up against this idea that we need to reconcile this global public good, the internet, with the problem of discrete state jurisdictions. And so I thought I'd just try to say a few words about that from this MLAT context that I think might be useful in other contexts. And some of my notes on this yellow paper is from my problem. So speaking of cross-jurisdictional problems. So the first thing that seems to me to be a lesson that we I think all agree on in the MLAT context that applies in other contexts is that you can thumb your nose at the state, but doing so has real costs. So there might be a short-term win to sort of sticking your finger to the state in order to enhance privacy or whatever it is, but there may be long-term costs associated with that. Leaving aside the question of whether telling a state, no, you can't get access to data in the MLA context is a good idea or bad idea long-term, or will in fact put a log on the fire of data localization efforts or won't. I happen to think it will. Drew suggested earlier that it won't. open question. It's totally an open question that we don't know the answer to yet. But here's a similar problem in another area. So I was at a conference at Stanford a couple of months ago to do with cross-jurisdictional, cross-border questions with regards to the regulation of speech content online. And someone there who has been a general counsel of a number of big tech companies basically said, I think general counsels should all give their finger to states that try to regulate speech anywhere in the world. And within a matter of hours, someone who was there, partaking in the conference and was a member of the CUNIL, French regulatory body, said, basically justifying the state's position that they have the ability to demand that an internet provider take down content anywhere in the world, which many people recognize as kind of an extreme jurisdictional claim. The response, the CUNIL person, sort of the justification that he gave was, what are we supposed to do when the perspective of the company representatives is, we want to stick our finger in your face, or poke a finger in your eye. And I'm not naming names, but these are real perspectives. This is the sort of political dynamic at play in a number of these issues. And I think it's counterproductive to be too dismissive of the state's legitimate interest in regulating on whatever these issues are. The second thing that I would suggest is that while states have legitimate interests, those interests have boundaries. And one of the tricky questions in all of these contexts is figuring out how one state's interests butts up against or needs to be accommodated with another state's interests. And here, some people think the solution is to craft an international treaty on encryption, on law enforcement access to data held abroad, whatever it is. Other people like me think that the best way to solve some of these problems is to rely on longstanding principles that have guided us in conflicts jurisprudence. Anyone who's taken a law school class in conflicts of laws knows we've been dealing with two competing state interests over jurisdictional claims for hundreds of years. Principles of comity and related ideas have been quite helpful for courts and legislatures in this space for a long time, and I think they will continue to be helpful in the internet space as well. So in the previous panel, and Greg was referring to this idea of comity, I think that's really important and will be relevant to MLA reform going forward for a very long time. The third thing that seems like a lesson from this space, but also others, is that lawsuits are a really bad way to make policy. So if you think about, like, on this question in particular, MLA, we have two pieces of potential policy that we've been talking about today. One is the Microsoft Ireland case, with an outcome that almost nobody likes. And the other one is the US-UK negotiated agreement, which, although there are people who don't like it, they're much smaller in number than the people who don't like the Microsoft Ireland case. And that's partly because it's the result of a thoughtful process and not just the resolution of a particular dispute between two parties before a court that is trying to solve a complicated issue, a complicated policy issue, with a set of doctrines that don't necessarily have much to do with it. And then the last thing that I would say about resolving these long-term jurisdictional questions is that we need to think very carefully about whether law is the right place to make the change or technology. So if you look at the encryption debate, much of the debate is intractable, partly because law enforcement's attempts to gain or claim the right to gain exceptional access are attempts to change the underlying technology. They think the solution to the encryption problem is to change the way encryption works. And anybody who knows anything about the technology, for the most part, it's like 99 to 1, thinks that that's a really bad idea, right? That the better place to try to resolve that debate is in the policy or law space. One of the things that I'm drawn to about the MLA reform efforts is that they start from the idea this is a law problem and we can solve it by negotiating a law solution rather than trying to affect the underlying technology. In fact, the thing that motivates a lot of us who work in the space is an attempt to preserve the underlying technology. So Google may have the data center distribution model we heard about earlier, Facebook might have a different one, and so on, but we ought to be able to come up with a negotiated solution to the problem as lawyers, as lawmakers, as policy crafters that allows companies to adopt the technology that their customers want. I will stop there and look forward to hearing the other panelists' thoughts.
Thanks, Andrew. two can't talk to each
Oh, that was tough. Because I want to respond to a couple things that you said.
other. I want you to respond to that finger in the eye of the country.
The finger in the eye of the country.
Yeah, is that your style?
Okay, well let's get there. So, shall I start? Okay, so we've been conferencing all day, so I thought I'd pick up on some of the questions that came up earlier today and try to fill in some of the gaps. Also give you a sense of how Microsoft is thinking about these issues, especially with regard to Europe, and that's because I'm based in our government affairs office in Brussels. So first I would say it was actually in response to your question, Andrew, earlier today. What is the secretive commission process? It's not secretive. You could join too, anyone here could. So just to let people know, what's happening there and how Microsoft has presented its positions, I think is useful, partly to know how to engage, but also to understand how, this is the long-term panel, so to understand all the different pieces that have to come together ultimately to achieve a solution, which indeed could take some time. So, going back to 2015, the European Commission prioritized the question of cyber-enabled, so not cybercrime, but cyber-enabled crime, so basically digital evidence. A year later, the Dutch presidency prioritized 3 tracks and tasked the Commission with focusing on that. So since July of 2016, the Commission has been holding a public consultation trying to address 3 different questions, all 3 of which I think we've touched on today. The first being focusing on practical solutions, things like templates, standardized forms. The second, looking at MLA reform, and third, this question around enforcement jurisdiction and trying to tackle the longer term question of whether legislation is needed. Way to approach these significant challenges with regard to jurisdiction. So, we have participated in those discussions, and frankly, I think it's the third question that has been the most challenging. The work of the task force so far has done, I think, a good job of defining what the challenge really is. And just to repeat here, because I haven't, shockingly, I haven't heard this mentioned so many times today, but one of the major motivators for Microsoft in this issue is the problem we find ourselves facing conflicts of law. And this has been a huge challenge, which has led to litigation. So just to respond to Andrew's point about litigation not necessarily being the best way to approach a policy question, we have, Microsoft takes very seriously when it may challenge the U.S. government, for example, which was the case in the Ireland case that he referenced. And in that case, if the company is under criminal exposure, there may not be enough options really to consider. So in this case, we pursued that question, and throughout the whole process, which isn't quite over yet, we've been trying to participate in a parallel dialogue around policy and put forth some ideas about how the current state of the law could be improved, because clearly things are not working based on that litigation. The next thing I wanted to address, it's kind of funny that I picked this question, but some of you heard the online question. How can I ensure that my data is safe from the government and from the big companies? And it's a big question, but I can tell you that it's a question that we get asked all the time. It seems very big, broad, but we get asked this constantly from our customers, whether our customers could be individual users, could be private enterprises, hospitals, schools. We are asked a lot of questions about lawful access. How can the government access our data? So this has been a particular point of sensitivity for us to address the questions that are coming to us. And I mean, it really goes to the very core of our business, and that is the development of the cloud and trying to to help our customers appreciate the scalability and the efficiency and the gains that they can from being able to move to the cloud. So this is why Microsoft has been so focused on this question. It's critical to our business, and it's been critical to the people who use our services. So the last thing I thought I'd mention would be, the potential. How does this all fit together, and why is Europe an interesting, relevant region to think about as we address, how a global solution might come together. The last session, was focused on a more narrow question about a single agreement between two countries, and I think it's useful to have that conversation. But what is of more interest to us is this discussion around the principles and the building blocks that would go into any kind of mechanism, and whether you can build consensus and agree upon some robust rule of law that could then be applied in multiple contexts. So, this brings me back to the process that's happening in Brussels right now, that's being led by the European Commission. Through that process, on the table right now is a question as to whether legislation is needed. There's pretty significant differences among the member states as to how they might approach this question. So in terms of what comes first, right now I think is the time. We've been thinking really carefully about the current status of things and trying to help make sure there's understanding about what could work and what might not work so well. And so we generally support this idea of a more common approach to jurisdiction. That I think is the opportunity. We're at the beginning of the process, and it's really time to think about reform from the bottom up, thinking about what the future looks like. And I'm also responding to Andrew's comment about, well, you're a law professor, and I didn't take that class. I feel like I'm back in law school many times in a week, trying to really grasp this question of jurisdiction. Because from what I understand, I turn to personal jurisdiction, subject matter jurisdiction, and then you think about the rules of territoriality and how those apply in the context of thinking about sovereign interests. So I think it is important to acknowledge that that digital evidence really transcends the traditional rules, which is why we're thinking carefully about how and what we might contribute to a new way of approaching jurisdiction. We're not close to having all the answers, but there are some principles I think we can learn from that are principles that have been around. A more recent one being that of mutual recognition. It's basically a means to alleviate the kinds of conflicts between member states. So at least internally or intra-EU, this is one principle to consider, baking in or thinking through how that might influence the development of rule of law around jurisdiction. There could be other components of a future framework that would take into account the question of addressing the problem of dual criminality when different countries have different approaches to what's a crime. It has come up several times today, this idea of having some sort of threshold around what is a serious crime. So there are, I think, transparency. And I think some of those ideas have been fully fleshed out in other contexts in the U.S. All the various types of principles we've heard referenced throughout the day. So I think it will be useful to turn to some of these principles that we've already publicly vetted and discussed, and turn our attention to some of the more, I think, technical and careful work that needs to be done around tackling jurisdiction. And then the other point where Microsoft is particularly motivated, getting back to this question of concern around government access to data that's stored in the cloud. We have long advocated for this idea of redirection, and that would be directing law enforcement directly to the source closest to the data, so that we're not caught in the middle of a transaction that would be more appropriate between law enforcement and the more direct source of data.
What does that mean? I don't get that.
You can pick any word you want. I change the word from time to time. So basically, a legal demand comes to us, and we may have a customer that's actually another service provider, and why shouldn't that service provider be having to make the decision about assessing whether or not that legal demand is compliant with the law? Why put us in a middle situation? You can imagine a circumstance where we have if you're a lawyer, which you are, and you hold the question of privilege very close, you might want to make that determination as to whether or not document data should be turned over to law enforcement based on privilege. There could be any number of other privileges that could be implicated by any of our larger customers that are governments.
You're not sending them to the target, you're sending them to a different provider.
Right.
To the target.
Right. Getting proximity to the source of the data. Yeah. So I'll stop there and answer any questions.
Kevin, it seems to me that any solution to this cross-border data problem is going to result in more disclosure of more internet users' information to more governments. Any solution will do that. Why is civil society groups, why are they pushing for solutions? Are they pushing for solutions? Give us the...
Yeah, so I'll answer that question very shortly. But I'll also say I like the mention of approaching this problem from the bottom up. Because I feel like if there's a theme to what I'm about to say, it's basically a stitch in time saves nine, and that we're approaching a generational or at least a decadal problem as if it's something we can resolve in 1 or 2 years. And that might actually make it harder to resolve it in the long term. I think as anyone who's been watching this today can tell, this is a super complex issue. There are no easy answers. For my part, my organization hasn't taken really many specific positions on this family of issues, except to the extent that we voiced some concerns about the implementing legislation around the US-UK agreement, sometimes similar to, sometimes co-authored with Greg and John to my right. So I mostly just want to offer a few observations, questions, provocations. Starting with, there is a legit problem here. There's an internet scale problem. There's exponentially more needs, more requests that need to be fulfilled because of the internet changing the game in terms of evidence. And to answer your question, privacy advocates' interest isn't to help law enforcement. I mean, that's fine. We want crimes to get solved, but that's not our equity. That's not our job. Our job is to protect internet privacy and internet openness. And our concern is that some of what Andrew was saying, all of these issues of lawful access fit together, whether you're talking about cross-border, whether you're talking about access to encrypted data, whether you're talking about government hacking, whether you're talking about extraterritorial fruitful areas to actually try to address governmental concern in order to avoid the parade of horribles such as broad anti-encryption mandates, throwing executives in jail, mandatory data localization especially. And so that's our interest. We think this is a more fruitful area where we can hopefully head off that parade of horribles. But that also means our greatest fear is ending up with an agreement that eases access and substantially reduces existing privacy protections while also not heading off those bad things. And I'm not quite sure how we do that. I especially don't know how we do that in the context of, and I think this is one of the biggest puzzles here, is whatever we do is going to have to address Brazil or India if we actually want to avoid those things, the mandatory data localization, the anti-encryption mandates, et cetera. Yet, a solution that doesn't encompass them is not going to actually foreclose the horribles. A solution that does include them will likely have standards that are much lower than what we in the US or folks in the EU would actually consider to be what's required by human rights. So that's a problem. But putting that aside, I wanted to question a few developing orthodoxies in space. First off, that allowing direct requests from foreign governments to US companies is the answer to the problem. First, I would say we haven't tried to fix MLAT. We really haven't. And I realize that there's you can say no matter what we do, MLAT's not going to scale enough. But come to me after we've done anything to address it. And I'm glad that we're talking about standardized forms, online portals, like things to actually modernize MLAT. But we need to actually do that and see how much of the pressure that takes off the system before we start talking about bypassing it. But if we are talking about bypassing MLAT and going straight to companies, which we are right now, I think that addresses the scaling problem because you're eliminating the bottleneck of the US government. But addressing the scaling problem, I think, doesn't require you to both bypass the US government and lower standards. Like, one of them should be good enough. If we're going to let the countries go directly to the companies, they should at least be able to meet the same standards they've been meeting. And if anything, provocative statement, if you're eliminating the government as a check, if anything, the standards should probably be higher to make up for that loss of the check. I know that's not good, but again, trying to just make some provocative observations here. And no, I can't unlock the device. There we go. I am worried about any. I'd say that a solution when you're considering the importance of maintaining strong standards in the U.S. is we're not just talking about cases where the data happens to be in the U.S. We're also talking about cases where, and this does happen, talk to any human rights practitioner, where people choose to store data in the U.S. because they are afraid, sometimes legitimately, of their own government. And they are trying to avail themselves of the strong protections in the U.S. Do we really want to take that away? I don't. Which brings us to the proposed short or intermediate term solution, which is the proposed implementing legislation for the US-UK agreement. Greg has explained a lot of civil society's concerns with this, and I would boil that down to, it sort of sadly takes the short-term path of, screw it, you can just skip MLATs and use your own law, and we'll bless that with some implementing legislation that purports to hold you to some sort of standard, but it's basically a political fait accompli that we're going to conclude that you satisfy. And basically, the U.S. government has said this in the context in regard to the UK in a variety of places where we've spoken about. And that's kind of worrisome. But let's look at the political landscape and how we're going to fare there when this actually gets debated it really hasn't broached the surface. We've all been talking about it for 2 years, but it hasn't really broached the surface in terms of U.S. politics and what happens when that occurs. Well, first off, putting aside kind, gentlemanly, rational scholars like me and Greg, there's going to be a wide swath of human rights and privacy stakeholders who are going to attack it for substantially lowering the existing privacy protections that protect people who use U.S. companies to store their data. And so that's going to be a factor. One unfortunate side effect of that is, for what it's worth, it'll be the first major split between the companies and civil society on the surveillance and privacy issues, surveillance and government surveillance and encryption and whatnot. We've had a very fruitful alliance with the companies on those issues for the past 5 to 10 years, and this would threaten to split that. I think that would be really unfortunate. But then, okay, also there's this Freedom Caucus. There's this far-right bloc in our Congress, and I think and they've just demonstrated how they can blow things up to help the Obamacare replacement. And I think it's a really interesting question. How are these far-right libertarian voices going to react to a law that basically makes it easier for foreign governments to get data from U.S. companies, including data that implicates U.S. persons' privacy interests, especially to the extent they're talking to people outside of the country? These Freedom Caucus folks who have supported surveillance reform in the past, have defended encryption in the past, I think they're going to be potentially very skeptical of this. Then, of course, there's President Trump, and really, God knows how he's going to react. There's still a lot of positions that haven't been staffed, a lot of policy positions that haven't been aired out, and it's possible Trump may love the idea because it's, law and order and anti-terrorism. He may hate the idea because it's catering to foreign interests without a really clear payoff for the U.S. and, America first. Or he may just not care all that much about it and decide it's not worth spending a lot of political capital and time on it. We really just don't know. Meanwhile, let's look at the international scene when this comes up in the U.S. First off, I think it's a really weird signal to send to international users of U.S. companies that in the face of them worrying about storing their data with U.S. companies post-Snowden, we're actually going to make it easier for other governments to get it. In other words, we're going to throw some GCHQ gasoline on top of the NSA fire that's been burning down international trust for the past 3 to 4 years. I don't understand why no one's mentioned how are international users going to feel about this, but I don't think they're going to feel great about it. And then think about the other countries other than the UK, because basically we're talking about having a congressional debate in the US to basically decide what we think the standards should be for the world when they want our data. And basically the only stakeholder we've really talked to or paid much attention to is the UK. That does not actually seem very respectful of international interests. And this brings me to a concept I meant to introduce earlier, which is in internet governance circles, there's this thing called the tussle. Whether you're talking about IETF or IEEE or whatever, they view part of their job as creating spaces for all the different stakeholders that have an interest to fight it out and tussle over what the right answer is. And I don't think the place to tussle over the answer for this is in Congress this year. I don't think the place to tussle over it is necessarily this room, but this is a helpful tussle space. I'm heartened to hear that both the European Commission and the Council of Europe are looking hard at these questions. But I think that the one big unanswered question is, what is the best tussle space for us to sort this issue out in a truly multi-stakeholder, international multi-stakeholder way to arrive at a solution that may take us a while to get there, but will be the right answer and will stand the test of time. And I don't think we're there yet. And I'm not quite sure how to get there, which is the hardest question of all.
No, that's a lot to chew on. Listen, if you'd like to join the tussle, just put your hand up. I'll make a note and we'll get to you. I'll engage the panel will engage each other for the next few minutes, but do a signal if you want to interject, because we want this to be interactive as much as we can. So just to follow up on one thing that Kevin said, Kevin, do you think that foreign users of the internet, foreign users of U.S. providers, will use U.S. providers in order to avail themselves of the protections of U.S. law on the criminal side? But what about the risks of access on the intelligence side? Do you think that it's a net positive for them, or do you think? What do you think?
One, I think often their threat model doesn't involve U.S. intelligence. Their threat model involves them, being thrown in jail for 2K, or some other behavior that we would think is consistent with human rights and something you're okay to do, but let's say Saudi Arabia is not cool. I don't think they're that worried about the NSA, but if they were, my answer to them would be, your data is actually better protected against the NSA in the U.S. than it is anywhere else. They never seem to buy that answer, but it is actually correct.
And what do you think? Are they thinking about these things, like Kevin says, or do they just want to get the service that works fast?
Yeah, it's really not an easy question to answer. Like finding it on this microphone. It's not easy to answer that question because it's not clear. I've asked a ton of people around the world what they think about this, and the answer is really run the gamut. And I think it kind of depends, as Kevin points out, what your threat model is, right? People who are upset about NSA spying will, in the same breath, suggest they don't want the U.S. government, quote unquote, seeing their stuff. But they also don't want any reforms to the system that would stop the U.S. government from being the gatekeeper to their data on the law enforcement side. There's a genuine tension, I think, and and most people are not getting more specific about what they mean when they say U.S. government.
And just to add to this, I mean, to some extent, this echoes the point you made earlier, which is under the current proposal, the UK could get anyone's data so long as it's not a U.S. person. How will the global community react to that? I doubt they will react friendly.
Lani, what do you think? Are users troubled when U.S. companies, or when U.S. companies, would they be troubled if U.S. companies advocated a system where their governments could get access to their data held by a U.S. company? Or other governments? Or other governments, yeah.
Yeah, the other government's question. I mean, I think based on what we hear, there is really real concern. A customer may be a government. They're concerned that another government may get access to their data. I mean, I haven't so much noticed this distinction, US, EU, you hear different answers. But one thing I do think is important is to think about this as, way up here. It's a global problem. And, focusing on this question around the US is not going to carry us forward 10 years. I mean, we don't know the next, European company that may, be wrestling with these same questions. It just so happens that, the big companies that have data centers in the US and now in Europe, we're all talking right now. But, it's an open question. So I think it's important to think about this in a more global way, which is why I was asking you the question earlier.
Do you think that the Commission and the European Parliament will kind of force this issue? They could, right, enact legislation that would compel a response from the U.S.
Yeah, maybe it's more of a question of sequencing. I think all governments are going to have to address this eventually. It's just a question of the sequence. What's faster? What's the political environment, and how do all of those different efforts ultimately fit together? There's a lot of questions about what's happening and what's moving in the U.S. It's hard to say exactly how it will turn out, but I think it behooves us to pay attention to the fact that it's on the table, will be discussed, and I think we'll see a report, I guess, in May as to whether or not legislation is being considered and is a possibility.
So Kevin, Andrew said at one point that lawsuits are not a good way to make policy in this area. In your career, you've brought some of the leading impact litigation in the surveillance arena. Do you agree?
I think that's pretty case specific. I think the problem with Microsoft Ireland is, and you can say this yourself, Microsoft's argument isn't that the US government should never be able to use a warrant to get data stored outside of the US. It's saying that the law doesn't currently allow that. And let's, take that opportunity to actually discuss what a sensible system would be. And so, I've heard Microsoft say in a variety of contexts that, the end of the case is not the end of the issue. Even if we win and say, and we come to the conclusion that ECWA does not reach extraterritorially, then that necessarily leads to a policy discussion in policy-making venues like Congress about what the right answer is. And so in that respect, on that issue, court is not the place to make the policy. The court is the place where you're trying to figure out what Congress' policy was.
Let me just say one thing too, which is a partial defense and also a partial indictment, or point out an inconsistency in something I said, which is that I said courts are not the best place to craft policy on these issues, but I also said we can rely on longstanding conflicts of laws principles which occur in courts. So we can sort of fudge some of the jurisdictional questions, which is what happens on many, many issues all around the world, and sort of general counsels try to figure out what happens when there's overlapping legal requirements from state A and state B, and you operate in both. And then ultimately they clash and there's a court case. But don't think that the court case, although they might be able to resolve disputes using longstanding principles, is crafting sensible policy. So Apple versus FBI was front page news, and everybody was discussing the policy of encryption backdoors But that case wasn't about encryption. It was about the All Writs Act. It was about 99% of it was about the All Writs Act. And the extent of one court's power to mandate something, which is not the place to have a sensible, holistic, thoughtful national conversation about encryption. That's.
I haven't seen any hands go up yet.
I would say my favorite sentence of the day is adding GCHQ gasoline to the NSA fire that trust on the internet. Was that new today?
Huh?
Was that new today? Did that just come out, or is that?
No, I've said that once or twice.
Okay,
This might be the first time I said it publicly.
it doesn't matter.
I can call on people, right?
Yeah.
Go ahead.
So besides the commission and the council, Kevin was pointing to Brazil and India as a central place because those are two governments that have been aggressive in this space about threatening companies and saying that we really are going to do it. And they're also big enough markets that none of the major companies want to abandon those markets. And they're not as far over the line as some authoritarian countries where they might decide not to play. So Devin Desai and I had this article that we didn't send around that much. It's just sort of the beginning of the thought, which is if you don't trust India, maybe we can have an office in the industry, in the right ministry in India. And it's a lot easier to monitor, the equivalent of CSIPs or something than it is to monitor 1 billion people. And you could say to the companies, if you get it from this gold-plated office, the equivalent of CSIPs, and there's an annual review of CSIPs, then the companies could do streamlined stuff. And India, for its highest priority investigations, could not have it come through a state court in Punjab, but instead it would go to the central place and they do it centrally. Because monitoring is so hard, monitoring of a very contained office is relatively easy. And an individual case could get a lot of attention in case it was being abused. So without it having been something that's been talked about a lot, do you have any initial reactions to that as maybe a more manageable version of this sort of, we'll call it comedy so that Andrew will nod his head even more. Do you have any reaction? I mean, this Greg and for any of you, is that more workable than saying all of India? Because maybe we actually could have 35 lawyers in India that get trained and live up to all this. Any reactions to that?
I did have one. In fact, it's something we discussed 2 years ago. One of the first things we discussed in the meetings was about, there's a distinction between deciding who's in and who's out at the country level and what kinds of requests are going to be allowed under this regime and what kinds of requests will be kicked out. Whatever system you set up, whether it's vet every request as they come in, regardless of where they come in, and analyze them based on the quality of the request and what's been articulated. You could also say you require a centralized in-house, in-country body.
Single point of contact.
Single point, yeah, right. The quality is going to range all over the place, but I think it's the same idea.
So in the MLS system, there has to be a central authority to make the original request, right? That's all the countries have those. So it shouldn't be such a big leap. On the other hand, I might see a country saying, oh, wait a minute. The reason that we could have a central authority for MLATs is because they were limited in number. And now we've got a world where we really, all of our investigations, almost all of our investigations involve digital evidence. And a lot of them involve digital evidence held by US providers. We can't just do the central authority. We'll overwhelm ourselves.
But that's up to India to staff it itself and to figure out its own priorities. And they don't blame the United States at that point for crazy US stuff. It puts it into India's power to fix it if that's what the problem is.
Yeah.
Right now, India feels powerless.
The bottleneck they keep complaining about is us, not them. And if I recall correctly, I feel like the US-UK agreement has a central point of UK contact through which the things route. And so I actually think that's an important feature for agreement with anyone, to sort of provide the level of ability of oversight and accountability that you're talking about.
Is that right for the? That was
pretty sure.
So some other decision maker around the UK would not be able to make a direct request. It has to get stamped by one office every time.
If I recall correctly,
I think that's right. That's right.
we all kind of think that's right. Pretty sure that's right.
Any other comments, questions from the folks in the audience? We can keep going here, but I wanted to give.
Let's just throw another little provocative idea out in terms of you're talking about the highest priority cases, prioritizing those. One way of approaching fixing MLAT, and just a provocative idea, have people pay for expedited processing of the most important cases. Like, I mean, one of the problems we have in terms of resourcing MLAT is we don't actually have an incentive to do it because it's not our freaking cases. Like, we don't care that much. Congress doesn't care that much. But if we were to provide a mechanism by which we could actually create the right incentives, I think international stakeholders might freak out if we suggested that.
Charging African countries for that.
But,
the U.S. doesn't have the money, so Africa does. That might, yeah. But
I mean, and to your point, Kevin, about MLA, the MLAT process, I don't think that we should think of this as a binary question. I mean, I think it's a perfectly acceptable position that MLAT is the default. I mean, we could all come up with, we're a bunch around some students. We could all come up with some crazy fact patterns that we've all seen, with the victim here, the data is here, it's charted in multiple countries, and it's just not solvable by any sort of, rule of law and, application of jurisdiction. So MLAT's the default. I mean, that works.
Yeah.
It alleviates the burden.
And I'd say, I certainly wasn't saying we shouldn't pursue, a voluntary regime because we have addressed MLAT. I think my concern is that we're really aggressively pursuing this voluntary regime without really pursuing at all meaningful MLAT reform.
How far can we get with MLAT reform? I mean, say there was a reasonable commitment to Congress to invest in the MLAT system and a reasonable commitment to have a common electronic form that other countries could look at and complete, a reasonable commitment to train foreign law enforcement in how to use the system, what kinds of information need to be provided in order to get a good response. How much of the problem, given its scale, could that actually solve?
I think that would buy us enough time to actually have the longer conversation we need to, like the full tussle that we need to have to figure out.
I don't know. I mean, I first of all, I think DOJ is making efforts in this space, but like Kevin points out, the incentives are just not there at the national level. The right people at DOJ who are saying we need more resources. They've gotten some, but it's not going to happen until everyone in this room has on their phone an app that was produced by a company based in some other country, and American law enforcement, in the wake of Microsoft Ireland, is needing to file MLAT requests, and suddenly there's an incentive to help out our partners with the same kind of speed that we want when we make our requests.
Can I make an observation? There was reform of U.S. law, I think it was 2014 or so that instead of having to go from Maine Justice out to Seattle or out to the Northern District of California, it can be done in a streamlined way in the District of Columbia. And that was trying to have a specialized set of people who could be repeat players and not have it go on to the desk of somebody 3,000 miles away. It was a sort of obvious place where if you look at the workflow, that was a pretty obvious one that actually has been done. The other parts of the workflow, it's not so obvious, you save many days. Mm-hmm. So if the United States is going to check all of the returned documents for whether they violate free speech or whether they violate less than probable cause, it's going to require government agents to basically read through the materials as a condition of sending it. That's not going to happen in a few hours. There's big requests and it's going to take a while. The companies need a certain amount of time to pull the data. It wasn't clear to me looking at the workflow there were obvious fixes. Maybe on the front end, so there's fewer of the bad request, try again, bad request, try again, you win on the third try. There's some room for help there, but I didn't see a workflow answer that really made a big difference other than that.
Well, I mean, responsive to that somewhat, one of the things I've found frustrating is that we often are in this discussion mixing up two issues. One is the issue of MLAT scope and scale. Like, why it's MLAT's too slow, MLAT's too slow. But at the same time, often MLAT is too slow because these countries are not satisfactorily meeting U.S. standards. And so one, we have to address the scale problem. I think that's a segregable issue, or at least we should theoretically distinguish it from the the internet scale issue from the I just don't want to meet another country's standard issue, and then sort of the sovereignty issues wrapped up in that. I think we need a solution that's going to try and address both of those in some way. But we keep talking about them together without parsing out where it's really a just internet scale issue and where it's really do we really have to satisfy U.S. law? Really? Come on, guys. So
I think there's also a lack of data that, the numbers that we have on incoming requests and outgoing requests, there isn't, DOJ could publish information that gives rather exact numbers, but they don't. They could publish information that shows how long it takes to respond to a request from X country and how long it takes to respond to a request from Y country. Maybe we learn something from that, and they don't. And I've never understood that. Why is it that they
Never understood why
do
they
that?
don't want to look back to most of the countries they deal with.
It's that if you actually want to fix the problem, often having data helps you do the right thing as opposed to doing things that won't make a difference.
well, and knowing stuff like how many of them are kicked back for lack of enough factual grounding versus it just being slow. That would actually help us diagnose the problem and treat the problem.
On that point, it's not just about not embarrassing the United States, not wanting to be embarrassed itself. It's also not wanting to embarrass international partners. So the DOJ, I talked to folks at DOJ who would say, well, of course, I won't name the Scandinavian country, but we have a great relationship with them, and the process is super quick. But I wouldn't want to publish the data about the country that sends us the MLAT request for the stolen chicken, which is embarrassing for them, and that took a lot of time to try to convince them that this wasn't worth doing and months to resolve. And that's not a win for anybody.
There actually was a stolen chicken MLAT request. And it's the kind of thing that you don't want to allow because it comes up the system. And makes so other requests that need to be acted on don't get acted as quick. Lani, one thing I heard about I'd like you to comment on is this idea of negotiating a protocol to the Budapest Convention that could start to deal with this issue on a more multilateral basis. Could you tell us a little bit about that, where that might be going?
Yeah, I don't know a lot of the details, but I think it comes back to the point I made earlier about sequencing. So there's a protocol that is being considered that would address requests for content direct requests. So, that dialogue is happening. I think it's more of a strategic question. We've all been discussing, do you fix MLAT first, or do you think about the bottom-up, review of the rule of law globally? Do you do the US, UK? There's so many different moving pieces here. But the way I'm thinking about what's happening with the conversation around the protocol is that it's good that there's this conversation happening in Brussels, which takes care of 28 member states who are party, or not 28, but a good chunk of Europe, which is part of that process. So again, it's kind of picking regions and doing the best you can to harmonize as much as you can and create these pockets which then fit together later. But I think that Europe comes before all the other countries involved in that process. But it is happening.
Let me take a minute to just thank you all for being here and to invite you to, in a minute or a minute and a half, because that's all we have 5 minutes left, to just wrap it up. Tell us what you think the long-term solutions are and where you think we're going and how long it'll take us to get there.
No pressure.
Just the best.
You go first.
Well, I actually think that the bilaterals show some promise. I think that we could get a small distance on actual improvements to the current MLAT system. I think that a multilateral treaty, I think there's a big risk it would lead to a worse result for human rights than would a series of bilaterals. I'm concerned about that. So not going to put a time frame on it. That was an unreasonable request that I made. But I think that's the road that is at least possible.
Yeah, I agree. And actually, I think that the future, people frame the future as like, we defend the internet and it's open and remains as open as it is today, which is not that open. Or it's the dark, fragmented, horrible splinter net. And I don't think that either is true. We're going to sort of hobble our way along, and there will be examples when states demand localization, and then there will be a response to that nasty development. There will be cases that are handled badly, and then there will be a response to the case. And I agree. I mean, I think despite what I said about cases, one nice thing about the way this develops, one argument against sort of big, comprehensive multilateral reform is that the world is changing. So, it makes sense to have small incremental steps, see how badly they work out, and then try to right the ship as we go along.
Lani?
Well, we've had so many conversations about the US-UK bilateral, and I think the positive part of all of this, we disagree, we're having a public dialogue, we're still friends, we want to stay in the tussle, we need civil libertarians to think about how you build rule of law. So all of that is good, having something on the table to react to and think about what works and what doesn't. It's so hard to give a timeline, but there is the worry that I do have is this is, we all, I think, acknowledge that there is like a very real and legitimate need for law enforcement to get access to data. It just needs to be done in the appropriate way. So, politically, there's these unilateral efforts that are taking place at the country level, and that really complicates things and is a motivator for some of the stakeholders who are really feeling the pain. So, I'm kind of pessimistic about the unilateral effort, but I want to be optimistic that we're having the dialogue, we're really wrestling with, some of these frameworks that we have on the table and can react to, try to fix and build consensus.
I kind of agree with both of them. I think whatever's going to happen, it's going to happen slower than anyone would like. I just reflect on the past several years of having these conversations and not seeing a great deal of expansion of this discussion into other venues where there's actual movement. Conversely, I think if something happens quickly, it's probably something bad that's happening quickly. So I don't know how to balance that. Some may be depressed by Andrew's vision of us sort of shuffling along, and bad things happening and good things happening. But I actually think that's the way life works, speaking generally, and that we're going to muddle along as best we can, and we'll eventually find some kind of solution, sort of. And by the time we finally have really locked it down, it'll be outdated and we'll be trying to find the next one, and we'll be looking at it like we look at MS now. That's the way history works.
And on that hopeful note, somewhat hopeful note, please thank the panelists.